Today I want to tell you about a very important Supreme Court case, Moore versus the United States. Our lawyers will be arguing for the Moores in front of the court. They will be arguing for the Constitution and for you. A few years ago, my friends Charles and Kathleen Moore, they received a large income tax bill because of an investment they made in a company called KizenCraft. The startup provides affordable power tools to small-scale farmers in India. Now, the Moores were shocked at their tax bill because they had never received any income on their investment. The reason they were required to pay a tax on income they never received is because of an isolated provision in the 2017 tax reforms. It's called the mandatory repatriation tax. This provision, they would find out, it works like a property tax, not an income tax. The mandatory repatriation tax was applied to them simply because they owned a part of a company. If you think that sounds like a wealth tax, you're right. The mandatory repatriation tax is essentially an attempt to write a federal property tax or wealth tax into law. But Congress can't tax whatever it wants. The rule makers, they have to follow the rule of law. Federal income taxes are levied when money is received by the recipient. A federal property tax would have to follow the Constitution's rules of apportionment, and the mandatory repatriation tax, it does not. It's not even close. If Congress can pass a broad wealth tax on the investments of folks like the Moores, it will affect the plans and decisions of millions of American businesses and families. We're helping the Moores fight against this unjust and unconstitutional tax, and we're fighting for the rule of law for millions of Americans. You can follow this case and all of our work at CEI.org.